The journey to fully understanding the administration of criminal justice law 2017 continues today. This is another edition of Wheel of Justice, which is brought to you by the Acjl State Administration of Criminal Justice Monitoring Committee and Prisoners Rehabilitation and Welfare Action, that is PRAWA, with the support of the Open Society Initiative for West Africa, OSIWA, and the Acjl State Justice Reform Team. My name is Ifeanyi. On last week's edition of the program, we looked at the institution of proceedings under sections 107 to 109 of the Acjl 2017. And my guest last week was His Worship Umar Onwonta, and she really did a fantastic job in dissecting that part of the law. Well, this week we'll be looking at the concept of first information report under section 110 of the Acjl 2017. And this afternoon, my guest is His Worship Elder Idika Udo Carlo. He's a Chief Magistrate Grade 1 and also Administrative Chief Magistrate for Umuahia North Magisterial District. Welcome to our studios.
Thank you very much. God bless you.
All right. Now, we'll be dissecting it. Before we take our first break, I'd love us to let's do an intro to this particular law. First information report. What are we looking at right here?
First information reports. We are talking of a complaint, a report to the police. Just like individuals can go and make a report to the police or a complaint, the only difference with first information report is that first information report now it is the police now reporting to the magistrate, complaining to the magistrate in writing of that which was complained to them either orally or also in writing.
Okay, so it's basically the citizen complains to the police and the police takes it over to the magistrate.
Yes.
All right. Now, we'll be looking at this some more very soon. But just in case, you can go over to our Facebook page. That is Flow FM 94.9 Umuahia. We are live. You can watch and see what's happening right now on that page. Don't forget that it's Wheel of Justice, and it comes your way every Tuesday from 3:30 p.m. We're going to take a very quick break. When we'll come back, we'll continue our conversation. And don't forget, we're talking about the first information report. Stay tuned. Welcome back. Still Wheel of Justice, and I am speaking with His Worship Elder Idika Udo Carlo, who is Chief Magistrate Grade 1 and also Administrative Chief Magistrate for Umuahia North Magisterial District. We're looking at the concept of first information report under section 110 of the Acjl 2017. And earlier on, he did explain that we're looking at the concept where citizens report a case to the police and then they report back to the magistrate. Now, let's go back into this conversation and look at other angles of this law. Let's look at subsection 2 of this 110 and get a better understanding of what it's saying.
Yes, subsection 2 states that the complaint, whether given in writing or orally, shall be reduced in writing into the police diary. In other words, when you are talking of first information, you start by the complaint because it is the complaint that metamorphoses into first information reports.
Okay.
So here now it's saying that the complaint, when made to the police, will be reduced in writing into the police diary. It is that which is reduced in writing into the police diary that later becomes the first information report when the said complaint in writing is now transferred into the first information report form.
Okay. Now, let's go to subsection 3 because of time, because I know we have lots of grounds to cover on this particular law.
Okay. You see, for a layman, this particular section 110, it deals with situations where it deals with the complaints where the police in charge of that vicinity, in charge of that station, has power to arrest without warrant.
Okay.
And also that the magistrate in charge of that district also has power to try the particular offense. That is the situation envisaged by section 110. So by subsection 3 you are talking of now, it said, where on any other ground the officers in charge of a police station has reason to suspect the commission of an offense. You know, I talked of complaint. Usually individual goes to the police and makes the complaint in writing or orally. This subsection 3 now, this is the situation where there is no such complaint. There is no complaint by any individual, but the police, either the police man in charge or his delegate, suspects that there are reasons to believe that a crime has been committed. That is what is envisaged in subsection 3. So he can still go on and put down his reasons for the suspicion into the police diary, and it now forms a complaint.
Now, I have an interest when it comes to subsection 4, where it talks about satisfying public interest. Now, let's get a better idea of what that part means.
Okay, this subsection 4. It says that where a police officer is satisfied that no public interest may be served by prosecuting, he may refuse to accept the complaint. Very important provision. So the police is not bound to accept to prosecute every information or complaint that comes to it. The police, when the complaint is made to it, if the policeman in charge of the station feels that public interest will not be served by prosecuting the offender for the complaint made, he can decline taking up the complaint.
Okay.
So it is not every complaint that an individual takes to the police that the police is bound to investigate, is bound to prosecute. That's what it is just talking about. But when a police officer is refusing a complaint, he must make the individual making the complaint to know of the provision in section 107 subsection E. That is his right to go to the court. That is the magistrate court in charge of that district to make the complaint to the police, the court.
That is a complainant taking the case to the magistrate.
Yes. Where the police thinks that it is not in the interest of public interest, it is not in public interest to prosecute, and declines prosecuting, then he will inform the individual of the need of his right to now go to the court and make the complaint directly to the court.
Now, are we looking at a situation where investigations happen immediately after a complaint is made, or does the police officer use his mindset to know if a case needs warrants an arrest?
Yes. Offenses, the law creating the offenses specifies whether the offender can be arrested with or without warrant.
Okay.
Where it is such that the police has to investigate, usually the complaint will be taken down, and after it is recorded, the next step is for investigation to commence.
Okay.
It is the investigation that will now convince the police to know whether to go on to prosecute or not. And if the police now makes up its mind to prosecute, it will now reproduce the complaint into the first information report, and now takes the first information report to the court in charge of that district, and the complainant and the defendant, the person against whom the complaint is made. Except where such a person is not in police custody, then it can go on to fill the processes required for arrest and all those, and then go on with the investigation.
Okay. Now, there's a part about referring a complaint to others' police station. That is in subsection 5.
Okay. Yes. In summary, that goes to deal with a situation where the police, after the complaint and recording of the complaint in the police diary and the investigation, and finding out that the matter is better dealt with in another police station outside its district,
Jurisdiction?
it can transfer the matter to that other station. But then there must have been a kind of investigation into it for the particular officer in charge to make up his mind that this matter ought to be rightly carried out, investigated, and concluded and carried out by the other station and not himself.
Sorry, if I may ask this question, what could prompt an officer to decide to push this case to another police station?
So many things: the interest of the parties, the convenience, the mode of prosecution, the danger that may be encountered by investigating it in that particular station where the report was made. Then threats and all that, so many things, logistics and all that.
Okay.
Like somebody in Aba coming to report a matter here in Umuahia, the distance and all that. Usually the police officer in charge will have every reason to know that such a matter will better be handled by the police station at Aba and not here in Umuahia.
Okay, now if you're just tuning in, I'm speaking with His Worship Elder Idika Udokalo, who is the Chief Magistrate Grade 1, and also his Administrative Chief Magistrate for Umuahia North Magisterial District. And we're looking at the concepts of first information report under Section 110 of the Acjl 2017. And so far, it's about where the complainant makes a report to the police officer. The police officer puts down the complaint and takes it to the magistrate. That is basically the idea behind it. And we're looking at everything that has to do with this law. Now, you talked about investigation of this case. Does that cover subsection 6?
Yes. Investigation, yes. Subsection 6 is talking about complying with the provisions of subsection 3. The officer in charge of the stations follows. That is, it goes to do with after recording of the complaint. What follows next is investigation. It is after this investigation now that the police officer will now reproduce the complaint, the said initial complaint he had, into what will now be known as the first information report. The police must have conducted its own investigation first before it will now become a first information report, before now reproducing it into first information report. So what follows here is the processes for investigation. Now, the complaint has been recorded, it has been read over to the defendant and signed by the officer taking down the complaint. Then the next thing he does is to start investigation, depending on the nature of the particular complaint that was made. If it is one that will require maybe going to the hospital for treatment of the victim or conducting other tests, he will go about that.
Okay. I once had a senior, that was about last 2 Christmas, where an accident happened.
Okay.
And the person who was driving the car actually slammed into the gate of an institution, killing the security officer there. And then, the case was reported to the police station closer. They came in and, made out to arrest the driver of this vehicle. A couple of weeks later, we got the news that this person had died. The driver had died. We suspected it could have been from internal injuries. In that situation, you're saying that according to this law, the police needs to refer that particular person, the defendant, to the hospital for treatment.
Yes, that is the primary. The first thing, once a complaint is made, the first thing to do is, if there is need to save life,
okay,
the proper thing should be to take the victim to the hospital. And usually there is what we call medical pro forma.
Okay.
Yes, at the initiation of investigation, police usually issues that medical pro forma to the victim, with which now we will go to the hospital and treatment will commence. It is on the same medical pro forma that the report of the outcome of the treatment will be recorded and now sent back to the police to conclude the case file.
Okay. Now let's look at subsection 7 and 8 because of time, because we're almost out of time.
Okay.
What does this say? Both of them.
Subsection 7 and 8 talks of suspects appear. Yes, where the suspect is now brought before the magistrate with the first information report. What takes place then? Usually the magistrate causes the first information report to be read out to the defendant, and the defendant has an option to decide whether he should be tried or not.
Okay.
If he has reasons to show that he ought not to be tried by the magistrate, in other words, that he is not guilty of what is being complained of, alleged there, then the magistrate will usually cause a charge to be drafted. He will draft a charge for the defendant to be tried on the offense, in which case the complainant will now be called on to give evidence of what happened and all that, and the defendant will have the right to cross-examine him, and at the end of the cross-examination, the prosecution, that's the complainant, will still have a right to re-examine.
Okay.
You see, but in practice, usually, what happens is that the police, after the investigation, prepare charge and arraign the defendant before the court straight away. In which case, the magistrate court will still ask the defendant whether he is liable or not to the allegations in the charge.
Sorry, that's in other words, that is, they are asking the defendant if he is guilty or not guilty.
Yes.
Okay. And
which he will answer. The answer is subject to evidence that will come later. Because once he says, he talks of the first information report, once the magistrate is now convinced that the defendant has suspects, okay, so we have the evidence, in fact, this section has been taken at any stage. The magistrate is of the opinion that there is ground that the suspect has committed an offense triable under this part, which such magistrate court is competent to try and which is in the opinion of the magistrate could be adequately punished. The magistrate shall frame a charge stating the offense for which the suspect will either be tried by the court or direct that the suspect be tried in another magistrate court. Okay. He can try if he feels that maybe considering where the offense was committed and where the parties are and all that, it is better tried by him. He goes on to try. If he feels it's in another magistrate district, he can transfer. Even where he thinks at any point in the course of the trial, that is after the defendant has been put on trial, he feels it is better tried by a high court. At that point, he will stop further proceeding in the matter and cause them to be transferred to the high court. Okay. For conclusion.
All right. Now, before we go, last week, our guest last week did talk about a situation where one can complain straight to the magistrate.
Yes.
And you brought that part in. That is when the police officer feels the case is not worthy enough.
Yes.
And says, you know what, advises the complainant to take it to the magistrate.
Yes.
Is there any other situation where someone can take a case directly to the magistrate?
Yes. One of the modes of instituting criminal action is that a defendant can go to the magistrate and go to the court on oath and make his complaint, whether orally or in writing. If it is orally, it will then be reproduced in writing, and the court, if the magistrate is satisfied with that the complaint that the crime has been committed by what the defendant has put down or has said, it can cause summons to be issued to compel the defendant to appear before the court. Okay. And then a charge framed and it will proceed.
All right. Anyways, today we just...
Go on. Okay. Go on. One thing is important.
Yeah.
For you to institute or initiate criminal proceedings in such a form, one, you must have reported to the police first. Okay. And they have failed. So to say, though even in failing, for the police to refuse to prosecute, they will give their reasons. They will their reasons have to be recorded in that complaint form. So, and they will inform you that you have a right to go to the court yourself. I think that is a kind of check the lawmakers put there.
Okay.
Yes.
All right. Thank you very much. I was speaking with His Worship Elder Idika Udo Carlo. He's the Chief Magistrate Grade 1 and Administrative Chief Magistrate for Umuahia North Magisterial District. And we've been looking at the concept of the first information report under Section 110 of the Acjl 2017. If you remember, at the very beginning of the program, we've always said that the Acjl is meant to protect not just the complainant, but also the defendant in every situation. And with each law, we also get to see it happen there. Thank you very much for coming again. Really appreciate your presence right here.
Thank
All right.
you.
Anyways, next week, Tuesday, will be another day. So make sure you keep a date with us on Wheel of Justice as we continue to dissect the administration of criminal justice law. And don't forget, this program comes your way Tuesdays from 3:30 p.m. It is brought to you by the Abia State Administration of Criminal Justice Monitoring Committee and Prisoners Rehabilitation and Welfare Action, that is PRAWA, with support of the Open Society Initiative for West Africa, OSIWA, and the Abia State Justice Reform Team. My name remains Ifani. Our stay tuned. There's more coming up at 4 o'clock. Flow Ride kicks off with Venus. Stay tuned.